Thank you, everybody, for joining. Comment that you can listen. Okay. So I'm here right now with Don, who is the chair of the National Parents Organization. Don, can you say something?
Yes. Can everyone hear me?
I'm hoping so. Let me see if I can manage the meeting. Hold on, gallery view. Let's do gallery view. Hopefully this will work. Yeah, now we can see you, Don. Great.
Okay, great.
So everybody, this is the first time that we're doing a live video with two people. So I hope that everybody, that this goes okay technically. But we're very excited to be here because we want to make some major announcements about what the National Parents Organization is doing. First of all, we want to invite everybody who is a member of National Parents Organization or who follows us on Facebook to be part of something that we're starting, which is we're going to call the Sharing and Comment Army. And basically what we want people to do who only have a little bit of time each month is to sign up with us, and you can just send us a direct message on our Facebook group saying, I will be willing to share and comment on Facebook and Twitter. This is super easy. Anything that we post, you just share to your own page, to other groups. You give a comment, you help respond to comments. And most importantly, when a op-ed is published in a local newspaper, a lot of times there are comment sections. And what we would like you to do is to actually comment on the newspaper pages. And this is very important because often the first people who comment are the ones who direct the conversation. So we're just asking for volunteers. If you're willing to do this, just send us a direct message or an email. And what's great about this is it's something that you can do a few times a week, just for a few minutes. And we'll actually begin to have somewhat of a schedule so we know kind of who's on duty to do those live and comment videos. Now, what's also really exciting is a few weeks ago, National Parents Organization launched its 2019 Shared Parenting Report Card. And the last one we did was in 2014. And the good news is some states made major improvements, but a lot of states didn't make as much improvement as we wanted. And today we have Don Hubin, who is the chair of National Parents Organization, but also Professor Emeritus at the Ohio State University, to talk about the research he did, but more importantly, how it can be used to create change and really direct the conversation. And what we found is sometimes just by having clear and concise data, we're able to create change without even having to be angry about it or to fight about it, because it just draws attention to glaring discrepancies that make no sense and that can't be backed down by science. So again, if you have any comments or questions at any time, just type them in the comment bar and I'll read them to Don and he can answer. But Don, if you could take it away and just start telling us about, maybe just start with why a shared parenting report card? Why is this even needed if most researchers and people say that both parents have equal access to their kids after divorce and separation if they're fit is a good idea?
Well, first, can everyone hear me? Ginger, are you getting a comment saying that?
Everyone says they can hear you.
Okay,
yeah.
Terrific. So I'm really excited about the 2019 Shared Parenting Report Card. We did a report like this in 2014, but that's been 5 years ago, and there have been changes in many states. And one thing I want to emphasize is that all the changes have been positive. All the changes have moved in the right direction. Some only by baby steps, some by giant leaps. But we've definitely had progress, and that's a great thing to be able to report. But of course, as many of you know, there's a lot more progress we need to make if we're going to bring all the states up to even passing grades, and certainly to get A's, which we would all like them to get. So let me just say a little bit about how this developed in 2014. We just started doing a survey of all the state statutes because we wanted to know what different states were doing. And as Ginger pointed out, there's a lot of discrepancy between the states, and that's a powerful tool because, as you know, every state says that the best interest of the child is the goal of their family law provisions. And it just does not make sense for there to be so many really radically different statutes in place, and all of them be in the best interest of the children. And of course, we know what the research shows now, and shows very compellingly, and that is that it is in children's best interest, except in very unusual cases, to be able to spend equal or almost equal time with each of their parents. So we started doing a survey of this, and then I realized that, you know, we need to evaluate the states and say how good their statutes are. And so we did that in 2014, and that had an impact. There were a number of states that responded to this, and we got some press coverage. I was finally able to return to this project in 2019, and with the help of a colleague actually from Canada who is very interested in what's going on in the States, a man named George Peace Corps, we produced an updated and enhanced report card. It's updated because there have been changes in a number of the states, and we wanted to reflect that. And it's enhanced really in two ways. One is that we have developed a mathematical algorithm, actually, that assigns the grades based on 21 different criteria that we do. And so that ensures that we have consistency of grading across the various states. The other enhancement I'll show you in just a minute, it's a way of visualizing the data. And let me see now if sharing my screen works.
Yes.
Okay.
Yay, technology.
Yay, technology. Sometimes it works. So this is our report as it was published last month, as Ginger indicated. It's available on our website.
Don, just let me stop right there and just let people know they can. I'm just going to type this in. It's that we have a special URL just for this called sharedparenting.org. It's super easy to remember, and that will take you directly to the report card. And you can also access it at nationalparentsorganization.org as well. Sorry to interrupt, Don.
Thanks. So the report, I urge you to read it. It's going to look like it's very long, but most of that is a long appendix where we have information on each individual state and the District of Columbia. So if you're looking at the overall number of pages, you can mentally subtract 51 pages from that. It's a lot shorter than it looks when you look at that, and you'll be most interested in your own state and maybe a few others that you want to compare it with. But in addition to evaluating the states and explaining how we evaluate them, it also gives you some information on research that shows the benefits of shared parenting, on what the recent changes are in various states, and those things can be very helpful to you in talking to legislators or to the media. So let me, there is an executive summary here, and if you haven't looked at it, let me just quickly summarize this. In 2019, 2 states received A. Only 1 state received a straight A, and that was Kentucky. And I'm going to say a little bit more about Kentucky in a moment here. We had 2 states that received Fs. That's New York and Rhode Island. Now, one of the things that's really important for everyone to understand and to explain when you're talking to the media or to legislators is this. The NPO Shared Parenting Report Card is a report card on the state's statutes, on what laws have been passed, been enacted by the state legislature. It's not an evaluation of what the courts are actually doing. In every state, courts have a great deal of discretion, and courts, judges and magistrates and referees, the people who are making the custody cases, if they're favorable towards shared parenting, they may be doing quite a bit of deciding quite a bit of cases in favor of shared parenting. If they're not favorable to shared parenting, they might be making a lot of sole custody decisions where they should be making shared parenting cases, even if the statutes are strong. So you have to understand that this is not an evaluation of what courts are actually doing. We don't have data. And when I say we, I don't just mean NPO. There is not good data available about the actual decisions that courts are making across the country. There are a few small studies in some states, but we don't have that data. So this is an evaluation of how well the legislatures are doing, the state legislatures, in enacting laws that really promote shared parenting. And the states of New York and Rhode Island have done nothing. Their statutes don't address shared parenting at all. They don't have any kind of a policy statement in favor of it. They don't have a preference for shared parenting. They don't have a presumption in favor of shared parenting, nothing. Those legislatures have not addressed this at all. I'm happy to say that after the publication of the 2019 Shared Parenting Report, we were contacted by someone who does divorce and custody mediation in Rhode Island, and she's going to start up a Rhode Island NPO chapter and try to get their legislation changed. And we have an active chapter in New York that's working there as well. But I want to underscore that this is an evaluation of the state statutes. So we talk a bit about how important shared parenting is and how the research supports shared parenting. And we talk about the success stories. So I mentioned Kentucky earlier. Probably a lot of you know that Kentucky has passed as a result of the activity of National Parents Organization in Kentucky. And especially I want to call out Matt Hale and also Matt Hancock there, who have done really incredible work. In the 2014 Shared Parenting Report Card, Kentucky got a D-, along with many other states. It had really very, very weak statutes concerning shared parenting. Now Kentucky is the only state to have a straight A. And that's because of two NPO-backed legislative efforts, one in 2017 that got a legal presumption of equal parenting during temporary orders while the court is looking at the case. And then in 2018, the statute was passed giving a legal presumption of equal parenting for final orders. The law has been incredibly popular among Kentuckians, and it looks like it's doing what we expected to do and reducing the conflict of parents going to court, because both parents are assured that they'll be able to retain the relationship that they have with their children. So let me show you what an individual state report looks like.
Don, if I could ask you a question, I know the answer to this, but what is, now that Kentucky has had its law passed enacted for over a year, have we seen any positive changes in Kentucky as a result of shared parenting that maybe people can also share with others? We
have, and Matt Hale, you know, I'm in Ohio, and Ohio is a neighboring state to Kentucky, and Ohio did not change its laws. And one of the, so Matt Hale in Kentucky and I have done some analysis of divorce cases and contested divorce cases. And despite the fact that Kentucky's population is growing faster than Ohio's population, they've seen a larger decrease in contested custody cases than Ohio has since the passage of the 2018 shared parenting presumption. So that doesn't just mean that fewer monetary resources are being wasted going through contentious court cases. It also means that parents aren't locked into the kind of conflict that is really bad for children. So that's one very positive effect that we've seen in Kentucky.
Has there been another effect regarding domestic violence?
So we have some preliminary results. Those are early, but we have some preliminary results that domestic violence charges during divorce are down. And that's a very positive result, I think. There was some concern that they might actually go up because the presumption in favor of equal parenting is undermined if there is domestic violence. And so there was some concern that people might be charging domestic violence for strategic benefit in custody disputes. But in fact, charges of domestic violence during divorce cases has gone down. So that's another very positive effect that we've seen here. Let me go to Kentucky because we've just been talking about it here. Yeah. So this is what an individual state report looks like. It has links that are active to the various statutes, and then it has the state's grade, and then it lists the positive elements of the state statute and the negative elements. And this is, you have this for each of the states here. So I just thought I'd skip ahead to New York since I mentioned that. And there's New York. And if you can see the page, you see the positives are blank because the state legislature has not chosen to say anything about shared parenting in New York. Now, I mentioned that there were two enhancements to the 2019 report card. One of them was that we developed an algorithm to ensure consistency in the grading. The other is that we have an interactive online map to help visualize the data. And so here is our map. And this is available. It's linked on our website. It is a map of the United States, as you can see, and we have the states listed by grades. I'm sorry, I'm not sure why it did that, why it reloaded. And if you mouse over a state, you will see its grade and the positives and the negatives. So in Ohio, for example, it has a list of all of the positive features of the state statutes and the negative features and the grade. I think this is a very nice tool to show the media, if you're talking to reporters, or to show legislators, and they can see how states compare. There's Kentucky. Arizona is the other state that did very well. It has an A- here. You can, if you want, filter it so you're not looking at all states, but you're only looking at the states that get an A. There's one peculiarity here, and that is that Hawaii and Alaska always show up. And that's because those are actually two different maps that we've superimposed on it. So you didn't have to see all of Canada between and the Pacific Ocean. But if you do want to look at states just that got certain grades, you can filter it this way. So, Ginger, has anyone asked any questions about the report card, how it can be used?
Let me see. So Deborah Shelford has a comment, which is, it is not in the best interest of the child to grant 50% custody to a parent actively alienating the other parent without supervised visits. So Don, could you speak to how shared parenting, what does fitness mean? And also what's the difference between default and imposed? Because I think people get this confused, saying what something is the default option versus every family must do this all the time. Right. So how does it work in practicality?
So let me start with the second point. And really, this is always a defeasible presumption in favor of equal parenting. So the court's hands are not tied. The court can deviate from this when the circumstances are appropriate. It's a question of what do we start with, and what do we think ought to be the parenting schedule in the absence of any reasons to do something else. Now, I mentioned earlier that domestic violence is something that undermines the presumption in favor of equal parenting, and so does child abuse. If a parent is engaged in a campaign of parental alienation, this is beyond just a random comment now about the other parent that's negative. I'm talking about a campaign of parental alienation. That is a form of child abuse. That is an attempt to deprive the child of the love of another parent that wants to be involved and is a fit parent to raise the children. And that sort of campaign of parental alienation is certainly the sort of thing that should undermine a presumption of 50-50 time with the children.
Great. And realistic. So basically, what we're saying is that there are cases where this would not be appropriate, such as
Absolutely.
Child abuse, domestic violence.
Absolutely.
And then also, are there cases where this could not work out for practical reasons?
There certainly are. And there are cases, for example, where the parents don't have any choice but to live far apart. And so 50-50 time is not going to work there. Or there may be that one of the parents is a long haul trucker and is on the road a lot, and that's not going to work. What we're trying to do is to set up the arrangement that has been shown to be best for children most of the time as being the default. And parents are always free to deviate from that. This is never something that's imposed over the wishes of both parents. It's if both parents go in and say, look, given our schedule, it works better to have a 35-65% split of time, and they agree to that, the court should say, you're the parents, and we defer to your judgment about what's best for your children, as long as neither parent is being, browbeaten into doing that. As long as, and one of the ways that parents get browbeaten into accepting a parenting arrangement that isn't equal is by setting up defaults that are even worse. So I'll say a little bit about the defaults that many courts apply when we talk about the Ohio study, Ginger, that you've asked me to say a little bit about too. But in brief, there are many courts that say, look, if you can't agree on anything else, then it'll be every other weekend and one evening a week for the non-residential parent. And then that non-residential parent may go into the court and agree to something that's a little bit more than that and say, I agree to this, but that's because they thought the option was they'd only get every other weekend and one evening a week. So we want parents to start with the assumption that they're going to have equal time. If that doesn't work for them for practical reasons, of course they can do something else. And if one of the parents is abusing the children in some way, of course the court should order something else. The point is not to impose a one-size-fits-all cookie-cutter approach. It's to set the starting point for discussions of these things in the best place.
Great. And then also, here's another question. Does shared parenting mean an exactly 50% split of time with each parent? So like, when you say shared parenting, are we talking 180, 180?
Yeah, so there's a definition of the term shared parenting that's used by most researchers, and that is that both parents have legal custody. That is to say, they have the right to make decisions about the children, and neither parent has less than about a third of the parenting time. That's the way most researchers define shared parenting. We define equal shared parenting as both parents have legal custody, they have the right to make decisions about the children, and the parents have substantially equal time. I mean, sometimes people get caught in a trap of, is it one day more or one day less? And that doesn't make any difference to the benefit to the children. So really we're talking about substantially equal time with the children. And let me say one more thing. What's really important to children is that both parents are involved in the ordinary parenting responsibilities, that one parent isn't put in a weekend, see the kids only on the weekend and only on a holiday sort of thing. So both parents are involved in, making sure the children do their homework, getting them to bed, getting them ready for school and off to school, because those are the things that parents do that children recognize as being parents' responsibilities.
Right. So one thing I want to add to that too is that not only will shared parenting help kids have both parents in their lives and have them recognize both parents as parents and form those bonds with them, but the hope is that by having this being the default option, this will reduce conflict. And this is also very important for children, that the conflict should diminish after the divorce. It shouldn't escalate with a war of who can get more time. And I also wanted to mention, Don, that one thing the NPO, the National Parents Organization, is going to look at in the future pretty soon is how, unfortunately, child support guidelines are often written to encourage fighting over custody time, and how this has to change. So child support is about supporting the child and not about a financial award.
Exactly. Yeah. Yeah. So I mean, it's very important the role that custody battles play in diminishing children's well-being. I mean, it's the emotional toll on children is substantial.
Right. So we're getting some comments. So I have quite a few, Don. So I'll start with Matthew Haley, who says, when one parent doesn't want 50-50, they resort to making false allegations to sway their courts in their favor. Why don't the courts punish spouses for false allegations?
Good. So that's another thing that you will be able to see in the report card. One of the things that we evaluated states on is whether or not they had a provision for an effective provision for dealing with false allegations. And you'll see one of the reasons you might want to look at other states other than yours is to see how they handle this and look at their statutes. So there are some states where it is considered to be a factor in deciding custody and deciding parenting time that one of the parents has made a false allegation for strategic benefit. And there are a number of states that have different and innovative good ways of dealing with this. Unfortunately, what many states do is to rely just on the statutory provisions of perjury. So that's something that you would have to bring a perjury charge against the other parent. I don't know the practices in all of the states, but I know that in Ohio, it is extraordinarily rare for a perjury charge to grow out of domestic relations cases. And both judges and attorneys in Ohio have said, well, that's because we assume that all parents lie. And so we won't do that. So perjury is not an effective tool for dealing with false allegations of abuse, but some states have specific provisions in the law to prevent parents, to discourage parents from making false allegations for strategic benefits. Good question. Thanks.
That is a great question. And another thing that I saw reading the report is that some states have, and Don, maybe if you want to switch back on your video now that we're done with the report, that some states also have what's called a friendly parent provision. What's that exactly? And how can that help people see their kids more and not have to fight for custody?
Yeah, so a friendly parent provision is one that says that one of the factors in determining what is in the best interest of children is which parent is more likely to facilitate a relationship with the other parent in the absence of there being good reasons for the other parent not to be involved. So we're assuming we're not talking about an abuser here, but the states that have a friendly parent provision says that one of the factors that courts have to take into account in determining how to award custody and what to do with parenting time is which parent is going to facilitate the relationship with the other parent. And Ginger, let me just say something strategically to something about the strategy of getting good legislation passed and why it's important, or it's often important to pursue a particular path to this. Kentucky got the success it got by first introducing a bill that created a presumption of equal parenting during temporary orders. That does a couple of important things. One is this: it removes from the opponent's set of arguments the let us do what's best for the children in the individual case. Don't create any kind of presumption. Because of course, when the court orders the temporary orders, it doesn't know what's best for children. There's been virtually no evidence. Usually there are some unchallenged affidavits that are submitted, or maybe there's a very cursory hearing. I mean, when I say cursory, 5 or 10 minute hearing before a judge. And then the court makes a determination. Well, why should you be taking one parent out of the full parenting role based on no evidence whatsoever? And so strategically, it's an easier argument to make that we shouldn't be removing a parent from that role when we don't have any evidence about what's going on. But it's also really important because if during temporary orders, you give one parent sole custody and the other parent the every other weekend schedule, and the parent who gets sole custody in temporary orders wants to maintain sole custody in final orders, it's in that parent's interest to say, we can't get along. We argue all the time. It doesn't work. If, on the other hand, you start with the presumption of equal parenting and the state has a friendly parent provision, then if one parent is making shared parenting not work, that's the parent who's least likely to get custody in the final orders. So it makes it in each parent's interest to try to make shared parenting work than to try to show that it won't work.
That's very important. So we're getting some more comments, and some are about personal cases, which we always have to explain to people. And this is something that we're fighting to change. We're an advocacy organization, and we don't give advice on individual legal cases. And one thing that we do talk about as an advocacy organization is the lack of resources for parents and how awful it is that as a parent, you have to pay incredible amounts of money to see your kids or for expert witnesses. So one question is from New Jersey, and it's from Deanne Dorney, and I'm going to just summarize, which is basically, well, this sounds great, Don, but what if you can't afford a psychologist to prove parental alienation? What if you can't afford a counseling center? And so how can we address this moving forward? Obviously, there's a lot of things that can happen in family court, and we have to start somewhere. But what about the people who say, well, I can't prove emotional abuse because it's so expensive? And I do know that sometimes an expert witness can charge $40,000 to testify.
Right. So I think it's there are some terrible cases like this where something awful is happening and it's just not possible to get the evidence that will convince the court. But I don't think it's always necessary to have an expert witness do things. There are judges who I know are very skeptical about parental alienation syndrome, whether this is really a syndrome, but everyone involved in family court has seen parental alienation behavior, behavior that's designed to alienate the children from one of their parents for no good reason. And I think that in many cases, you simply have to let the facts do the heavy lifting. You have to document what's happened. If you're in a state where you can record telephone calls without the permission of everyone involved, some states allow you to record telephone calls with only one person on the call knowing that it's being recorded. And if some of the alienating behavior takes place over the phone, then record those and submit that. Otherwise, keep a journal and document the things that are happening and present that to the court. I don't know that it always helps that much to have expert witnesses, because the other side can often bring in their own expert witnesses and you just get a dueling between the expert witnesses. I think you just need to present the facts in as compelling a way as you can to the court.
Right. And also one thing that National Parents Organization and a lot of allied groups are fighting for is by creating these presumptions and a cultural shift, that these cases don't have to be decided in court. And the other thing about the presumption of shared parenting, and because a lot of parents say, oh, I have shared parenting, but it's not enforced. If the entire system really said, we need both parents when they're fit in their kids' lives, and if there's a problem that can be worked out, they need help, here are resources, we're going to accompany the parents, things would be a lot different. Because right now, family courts, what they do is they play a blame game. They try to put in, try to figure out who did something wrong as opposed to what can be done to help. So while we often talk about shared parenting, changing the law or changing court procedures, we're also talking about a cultural shift, a societal shift of recognizing that this is the best option. I think a good example of this is how, not every state has laws against spanking or hitting children, but there has been a huge cultural shift over the past 50, 60 years where most people would say this is not acceptable. If they see a kid being hit, would say something. People know that this isn't just a family matter. When my parents were younger and they were hit, the response was, well, we don't care about this. This is a family matter. Don't complain about it in school. And that's a huge cultural shift. And it wouldn't be great if only one parent shows up to school events, the school would say, well, where's the other parent? How can we get them involved? As opposed to just saying, well, that's the way it is. We don't have time for this. This isn't important. So this is the kind of what we hope default shared parenting does, isn't just help these cases, but really create a culture of saying, what can we do to help families heal, keep both parents in their lives, as opposed to picking out who's the slightly better parent, causing a lot of money to be lost and a lot of stress. Drew Love just says, thank you both for all this information. Thank you, Drew. Are there any questions regarding how to use this report card, talking to people in your state, talking to the media? So for example, Don, here's a question that I think I'll ask on behalf of everybody. The report has a lot of good information. A lot of it is very detailed. What if we're talking to the media? Because often the media doesn't have time for such detailed analysis, unfortunately. So what are some things we can lead with, or some phrases we can use that grab attention and really make this simple and child-focused?
So I think the thing to lead with, first of all, I think it's really important to make clear that our goal is to promote the best interest of the children. And the best interest of the children, now we have 35 years of research that speaks as compellingly and consistently as social science research ever does, that shared parenting, substantially equal shared parenting, is best for children. We have some of that research on our website. Some of it is referred to in the report card, but more is on the website. And if anyone wants to write to me, I will send them even more research on that. The social science research is on our side. Now, a reporter is not going to want to know all the research, but you can say confidently that the social science research shows that this is what's best for kids. And in the countries where this is a sort of cultural norm, as we'd like it to be here, children of divorce do much better than children of divorce and sole custody arrangements. In fact, the research shows they do about as well as children in intact marriages. So you can just say, you know, what's really bad for children in divorce is not the divorce itself. It's how we handle the parenting after divorce. It's that we take one parent out of a full parenting role. That's a simple message, and it's one that you can be confident is backed up by good social science research. And you can say the states are all moving in the right direction. All the states that are moving at all, I should say, are moving in the right direction. Most of the states aren't moving, and we're working on that. But all the motion is in the right direction. And point to Kentucky. The temporary orders bill, when you're talking to legislators, the temporary orders bill passed Kentucky with no negative votes in either the Kentucky House or the Kentucky Senate, 0. I don't think you can get a resolution that apple pie is good to pass in our hyper-partisan divided times unanimously in that way. The 2018 bill that created a presumption of equal parenting for final orders passed with only 2 negative votes in the House and no negative votes in the Senate. So this is something to point out to legislators. These are very popular bills. We just did a survey in Virginia, and we asked people a number of questions about shared parenting. One was, do you think it's in the best interest of the children when the parents separate to have substantially equal time with both of the parents? 93% of Virginians said yes. And then we asked—
I'm going to type that out. That's 93%. Does anything else pull that high?
Yes, one thing else pulled that high. We asked Virginians, would you be more or less likely to vote for a candidate who supported a presumption of equal shared parenting? 93% of Virginians said they would be more likely to do so. And so this is overwhelming support, not only for shared parenting, but for a legal presumption of shared parenting and for voting for candidates who support shared parenting. That gets legislators' attention. But it's important to see this support for shared parenting cuts across political party affiliation. It cuts across who you voted for in the last presidential election. It cuts across racial segmentation. It cuts across age, and importantly, gender too. There's overwhelming support for a legal presumption of substantial equal shared parenting across all of those demographics. That gets reporters' attention, and that gets the attention of legislators.
That's very true. And so I think when we present this, we have to speak with the confidence that we are on the winning side of history. This has wide support. And really the only people who aren't supporting this, unfortunately, are certain elements from the judiciary and the bar associations. The good news is we are in contact with more and more lawyers, and I hope judges as well. I have talked to some who really support shared parenting. In fact, today we're going to be announcing a new affiliate that's led by a divorce attorney who has done mediation for about 20 years, is writing a book on shared parenting, had shared parenting in her own divorce case, even though it wasn't allowed in the state when she started, and she really wants to change the culture. So another thing, if you're working in your state, is to identify ex-judges, judges, and lawyers who are willing to speak out against the bar association, because the real reason why they are against shared parenting is because less conflict equals less billable hours. This does not mean that all lawyers are like this. And there's a movement towards what's called collaborative law. And this is mediation. I know a lot of people have had bad experiences with mediation. This is mediation that's really designed to deal with high conflict cases and has the power of the judiciary behind it. And also what we believe is that it should be offered free or low cost, right? So it's also finding those key people who can speak and say, look, I'm a divorce attorney. This is really bad. And someone just said a comment, which I won't even ask you, Don, because I'll just answer this. But about, do states who did well on the report card have a family court with dedicated judges? In Colorado, we have judges who rotate in and out in other courts. We didn't really, look at that, but that is a problem that you have judges that rotate. They don't really care about family law, or sometimes are assigned as a punishment, or who do civil and criminal law. And you really need a different mentality to help a family than to throw somebody in jail for shoplifting or murder. Let's see if we have any other
Ginger,
comments.
if I can add,
Sure.
we recognize that judicial education is really important. As I said early on, the statutes are always going to give judges a fair amount of discretion in these cases because these are subtle matters about what's going on in the family and so forth. So they'll always have some significant discretion. And so it's important for us to educate judges. And NPO has begun to talk about ways in which we can create programs to educate judges about the social science research. Most judges really want to do what's best for the children, and they're often overwhelmed and they don't have time to read studies. So we're talking about designing continuing legal education classes that'll bring the research to them so that they will embrace the legislative changes that we're trying to push and not resist them.
Exactly. We think this is very key because what's interesting is it's this small sector that's not supporting, and they do have a lot of power, but also if the more and more judges and lawyers who speak out against this and who say this is really what's best, we want a simple thing, because the other argument in supporting shared parenting is that the cases that are really, really difficult, that there's clear signs of abuse, you really need a lot of resources spent on those cases. And right now, these resources are kind of being spread across all of these cases that really shouldn't be in court. They should be settled outside of court. And I also want to just post the video from the shared parenting report card. I just posted in the comments. We did a press release in New York, which got an F. And one of the comments from one of the mothers was that she filed for sole custody because she thought that was the only thing possible. She did it through a judge. A 3-year custody battle resulted in this. And then she ended up losing custody. And if she had known that shared custody was an option and the best option, she wouldn't have even done that. She had no idea. And now is a huge shared parenting advocate and created an organization called Amazing Moms Without Custody. So this is about education, and she's like, all of this time and effort, could have been saved if she had just known this was an option. And I have a great question for you. Don, you answered this earlier, but I know Michelle Stigl-Jordan was not on the call. Is it possible to do a single state report card about different parenting guidelines? And the answer is, we have done this, Michelle, and Don will say about why we can do it in other states and maybe not all states.
That's a terrific segue into this. So I'm going to share my screen again here.
Yeah.
Let me know if this works right. So I'm in Ohio, and let me just give you a tiny bit of background here. I've been involved in divorce and custody reform activity for quite a while now, and over the course of those years, I have many times heard an attorney or a judge say, well, you people who are trying to promote a presumption of equal parenting don't recognize that every case is different and you can't use a cookie cutter approach. And I heard that hundreds of times over the years, and finally got rather frustrated. And I said, I was meeting with 2 leaders of our Domestic Relations Judges Association, and I heard it for the 501st time. And I said, your court has a parenting time schedule, and it's a default parenting time schedule. I don't know what it is, but I'm betting it's every other weekend and 1 evening a week. And they didn't really have an answer to that. But that spurred me to decide to do a study of Ohio's parenting time rules. In Ohio, by statute, every county has to have a parenting time schedule it's intended to function as a default. And so together with a couple of colleagues, we studied every one of the 88 counties. And we found that 64 of those 88 counties had a schedule that gave one parent only every other weekend and 1 evening a week or less. Some of them only gave every other weekend time to one of the parents. So we wrote a report here, the NPO Ohio Parenting Time Report, which is available on the website. But I also want to show you unfortunately, it's not, here we go. The map that we created here to display the results of this. So This is a map of Ohio. I think I can make this a little bigger here. Yeah. This is a map of Ohio, and like the map we did for the national report card, if you put your mouse over one of the counties, you will get information about that county's parenting time guidelines. And you'll see that in many of the states, it is the non-residential parent has only 54 hours in a 2-week period. That's the every other weekend and 1 evening a week schedule. So there are a couple of things I want to say about this. One is that this exercise shows that there are multiple ways to promote shared parenting. One is through changes in the state legislation. But since NPO published this in August of 2018, 5 counties have changed their parenting time guidelines as a result of the pressure that we brought to bear on them. And all of those counties improved their parenting time guidelines. 3 of the counties went from having the every other weekend, 1 evening a week, to having a presumption of equal time with each parent. And 2 of the counties changed from having, one of them actually had less than every other weekend and 1 evening a week, but they changed from terrible schedules to having multiple schedules that they offered parents, which at least shows parents that there are different ways to do this. And as Ginger pointed out, there are lots of parents that go into court without an attorney, and they don't even know that they can do something different from the schedule that the court offers there. So we've made an improvement in the practices of Ohio courts without changing Ohio law by doing this state level study. Now, Ginger said that I would explain that this can work in some states and won't work in others, and that's for the following reason. Some states don't do this at a county by county level. Some states have a statewide default parenting schedule. And in that case, of course, you can't compare one county to another. And the other thing is that some states actually have a provision saying that the counties aren't allowed to create a default schedule. So it won't work in those states either. But if you're in a state where different counties have what's called a local rule that provides a parenting schedule, then you could study these local rules and you could compare them. And it was very dramatic and very effective in working with legislators to, for example, compare Tuscarawas County here in Ohio, which got an A, which is one of the states that had an A right from the start, right from last year, with a neighboring county like Harrison or Stark County that got Ds, and say, look, you have 2 families, they could be living 2 miles apart, one of them in Harrison County and one of them in Tuscarawas County, and their parents get divorced. And in one of them, the kids see each of their parents about half the time, and the other one, they go 12 days without seeing the other parent. And why is that? And how can both of those rules be in the children's best interest? So it's a very effective tool in dealing with the media and in dealing with courts and in dealing with the legislature as well.
Right, and also, so Don, if you can go back to the video. So we definitely want to do more studies like this, and it definitely shows that there's no scientific evidence for these different parenting guidelines, because what researchers say all the time is that if a parent is fit, they should be in their kids' lives, and if not, then there needs to be a problem why that would be very detrimental to the child. But there's no reason for all these custody evaluations that come up with a finding that it should be every other weekend, because if you can have the kid for a weekend, you can have them for a week.
Right.
That's what the research shows. Michelle Jordan also asked another great question, which is how can we get this to judges? And I think something that we do need to work on NPO is a plan to mail or email this to judges and lawyers just to make them aware of this. We encourage people to print out the study and to give it to their judges. And we also are working on handouts that are state specific. And another thing that we can do, especially I mentioned before, and if you're just joining us, we want to create a comment and share army. Very basic. You're on Facebook, you're on Twitter. We have a post, share it to your own page, share it to groups, comment, respond to comments, comment on the websites of newspapers that run articles about this. But starting tomorrow, or possibly Monday, but I think tomorrow, we're going to be sharing memes, little images for each state. So I'll say, you know, Alabama got a C- and why, and we can share these on Facebook. But we encourage everybody to go to the NPO website, if you can, print out the report or just send a link in an email, and the information is there to be shared. So feel free to email it, share it, print it, and hand it out. And what's great about it is I know a lot of parents, they feel uncomfortable talking about their own case. We often say, don't talk about your own case when you're talking about this. People don't want to get involved in a custody battle. But you just say, hey, I'm presenting research. It's from a professor of the Ohio State University. He's a professor emeritus. It's been all this peer reviewed. It's been picked up by Fox News, by US News and World Reports, by parents.com, by Yahoo, over about 25 op-eds at the state level, maybe even more. So this is very good, scientifically done, solid research, and you can let the research do the talking for you. So it's a great tool to have, so you don't even have to give a speech or talk. You can just leave that report card. So we will be working on a plan to make sure this is disseminated in family court system. And wouldn't it be great if just by looking at this, some judges begin to change the way they rule, some counties change their guidelines, and maybe the judges and the bar associations won't oppose the march towards shared parenting, the inevitable future where all states have this as the default option. So I think we're almost at an hour, and we are out of, and there aren't any more questions. So just to wrap up, remember that polls overwhelmingly support shared parenting. And what's interesting is every time NPO does a poll, no matter what the state is, the numbers go up. So a few years ago, we were at 75%, and the most recent poll in Virginia, 93% support. It cuts across party lines, ethnic groups, gender groups. Everyone is on board with this. The research backs us up, and the shared parenting report card shows that change is possible. Kentucky went from a D- to an A, thanks to the leadership of Matt Hale, Matt Hancock, and all the great people at the NPO Kentucky. Arizona also got an A-. And what's great about Arizona is it doesn't specifically say the shared parenting is the default option, but that's how judges interpreted it. So getting the judges on board is really key. And also that to look at, even if you're not in Ohio, look at the Ohio report that Don did, because it shows how it's not that each judge is deciding each case differently. These counties do have their own guidelines, and they're not based on science. And why does a family from one county have a completely different parenting time than another? And then also, just to wrap up, we will be sharing these memes starting tomorrow. And we have, in the past few months, opened up 4 new chapters. I see Dawn from Florida on here. We also opened up Wisconsin, Texas, and Rhode Island recently. I think I might be forgetting one.
Wisconsin,
yes, and Wisconsin.
Connecticut.
And Connecticut.
Yep.
So Connecticut, we're going to open up soon.
Yep.
And California, we're working on revitalizing the leadership. But if you want to join a local NPO chapter, on our website, we have a list of all the chapter leaders. You can just email them, or you can contact us about starting a chapter. And what each chapter gets isn't just the name of being the NPO chapter. First of all, we are vetting to make sure that each chapter leader really is up to the task. But we also have created a roadmap that really shows how to build on the success of Ohio and other lessons, and gives you strategy options. Each state is going to know the best strategy for them, but we want to share best practices, work with other groups and coalitions who are already working on this. And it's also very important to us that each chapter reflects the diversity of its state, that we have equal numbers of men and women in the chapters and different voices, because not only is this important, but each community can talk about how shared parenting affects them. And we've had a lot of feedback from states that, certain representatives, they want to hear, if they're representing the Native American community, they want to hear the issues that are affecting the Native American community. That's just one example I got from New Mexico. And Don mentioned how judicial education is really important, and we'll be working on classes and seminars for judges and lawyers. So, because they're actually the last group to really get on the shared parenting bandwagon, and they need to be leaders in this. And if you're working on this, identify the judges and lawyers, even if they're retired, who have seen what's going on in family court and support shared parenting. They're out there, mediators, collaborative lawyers, and retired family court judges are often very willing to speak about this, because they're tired of seeing a waste of time, resources, and families being destroyed in custody battles that should not be happening to begin with. So again, sharedparenting.org to look at the report card. Don, do you have any closing remarks before we?
Nothing but Ginger, thank you for arranging this and doing this. It's terrific. And I've been telling people I am more optimistic about our success now than I've been ever before in the movement. It's clear that this is a wave that is coming, and it's going to move lots of states forward quickly, I think.
Wonderful. Well, thank you everyone for joining us. Remember, you can join a chapter or set one up, and you can find the report card at sharedparenting.org. Please share, and also get in touch with us if you want to join our Share and Comment Army. Thank you so much and have a great night.
Thank you, Ginger. Thank you all.
Bye.